There are many laws in the United States that don't make much sense. And today, we're going to look at one of those laws that has been on the books since 1973, and it still makes no sense whatsoever. In the United States, we have this thing called double jeopardy. The idea is if someone is charged with a crime, they can't be charged again for the same crime. This ensures that people aren't continuously harassed by prosecutors who just keep trying different things until they get a conviction. But what happens when you're recharged with a crime but the evidence isn't strong enough to get a conviction? In that scenario, the prosecutor could just drop the charges and then bring them again later. So, to prevent that, the United States has this rule that says once a trial starts, the prosecutor can't drop the charges unless the defendant agrees to it. Sounds good so far, but here's where it gets weird. What if the defendant doesn't agree? Well, in that scenario, the trial continues until there's either a conviction or an acquittal. That all sounds pretty straightforward. Where it gets weird is with this last part. If there's a hung jury, meaning the jury can't come to a unanimous decision about whether the defendant is guilty or not, then guess what? The government gets another crack at trying the case. They can pick up the charges and try the case again. Today, we're going to talk about a law that allows the government to do that repeatedly, over and over again until they win. It sounds crazy, but it's real. This is the one where a man was tried 48 times for the exact same crime and convicted 48 times. It all started in the 1970s when a man named Samuel Little went on a crime spree. He robbed banks, grocery stores, and gas stations all over the United States. At the time, there were very few nationwide databases about crimes and criminals. So law enforcement didn't know how widespread his crime spree really was. Eventually, he was caught and taken into custody. He was charged with armed robbery for one of the bank heists. He pleaded not guilty. After 2 hours of deliberation, the jury said they were hopelessly deadlocked. The judge declared a mistrial. Soon after, he was retried for the same crime. This time, the jury took only 30 minutes to reach a hung jury. He was tried again and again and again. Each time, he pleaded not guilty, and each time, the jury couldn't reach a verdict. He was tried for the same crime 48 times in total, which is a new American record for most trials for the same crime. Eventually, he was tried in Florida for armed robbery. This time, he pleaded guilty. He was sentenced to 20 years in prison. While awaiting transfer to a Florida prison, he was interviewed by the FBI. They learned that he had committed at least 50 robberies in 15 states between 1974 and 1975. All of these were technically separate crimes. After serving 20 years of his sentence, he was released. To see if he'd committed any more crimes, he was placed under the supervision of a parole officer. 3 days into his release, he was arrested for attempting to break into a vehicle. When police searched the car he was trying to break into, they found several items inside, including a handgun and some ammunition. It turns out he wasn't supposed to have guns or ammunition because of his prior felony convictions. He was sent back to prison to serve the remainder of his sentence, which would be up to 10 years. So now he's back in prison where he belongs. You might think that the ordeal was finally over for him, but just wait. A few months after he was sent back to prison, the state of Colorado charged him with a robbery that happened in 1973. Now remember, he already pleaded guilty to a robbery in Florida from 1974, but in Colorado, the statute of limitations for robbery is 6 years. Since the robbery in question happened in 1973, the statute of limitations had long since expired. So why are they charging him now? Well, the reason is a little complicated. Remember, when he was first arrested for a robbery in 1974, he pleaded not guilty. Then the jury couldn't reach a verdict. So the prosecution tried him again. This time he pleaded guilty. But since the 1975 robbery in Florida was considered a separate crime from the 1973 robbery in Colorado, he hadn't yet been tried for that original robbery in Colorado. So even though the statute of limitations had expired, the government still decided to prosecute him. They charged him, he pleaded not guilty, and the judge dismissed the charges without prejudice. What does that mean? It means he could be charged again. And sure enough, a year later, he was charged again for the same crime. This time he pleaded guilty. He was sentenced to 4 years in prison, but since he was already in prison for other crimes, this sentence was served concurrently. So he wasn't in prison for more than 5 years. But here's the kicker, even though he was already convicted for that crime, a few years later the government charged him for it a third time. By this point, he was already out of prison and living under the supervision of a parole officer. His parole officer didn't want him to go back to prison for the third time, so he convinced the district attorney to drop the charges. And that was the end of it. Now, at this point, you might be wondering how something like this could happen. How could the government keep trying to prosecute someone over and over again? Well, it all comes down to this. In criminal cases in the United States, there's something called the Double Jeopardy Clause. This clause prevents someone from being tried twice for the same crime. But the Double Jeopardy Clause only applies if the defendant actually faces jeopardy at trial. What does that mean? Well, jeopardy begins once a trial commences and the defendant is put to his or her rights. But jeopardy ends once a trial ends, so let's look at Little's case again. Every time he was tried for a crime, he pleaded not guilty. This meant that he was exercising his right to a trial by jury. Once a jury was sworn in and the trial commenced, he was put to jeopardy and the Double Jeopardy Clause kicked in. But since he kept pleading not guilty, the trials kept ending in hung juries and mistrials. Each hung jury and mistrial ended the trial and therefore ended the jeopardy. This allowed the government to start new trials every time. Now, you might think this is crazy. And you're not alone. Most people think this is crazy. But this is exactly what the law is in the United States. This is a doctrine called multiple persecutions, which is based on the Fifth Amendment's Double Jeopardy Clause. This is a decision made by the U.S. Supreme Court in 1973. The court ruled that the Double Jeopardy Clause only applies if the defendant is put to jeopardy. If a defendant pleads not guilty and goes to trial, then the Double Jeopardy Clause kicks in. But if the defendant pleads guilty, then the Double Jeopardy Clause doesn't apply. This means the government can prosecute someone over and over again if they plead not guilty. Now, you might think this is crazy, and you're not alone. There have been lots of people who have tried to change this law, but so far no one has been successful. Some states have tried to pass laws that say once someone is charged with a crime, the charges can't be dropped unless the defendant agrees to it. But these laws have been struck down because they violate the U.S. Constitution. So for now, this is still the law in the United States. Maybe it will change someday, but who knows? Thanks for watching.